Mr. Goodyear, because he bears the burden of proof in this case, will address you both first and last with Ms. Kirby.
Now, in opening statement, I began by telling you that this is a case about exploitation, about a 45-year-old and 47-year-old man taking advantage of a 13 and 15-year-old girl. And when you think about this case, I would ask you to think about State's Exhibit 1. This is the trauma letter wrote when she was in therapy, and you got a chance to hear her read that letter to you yesterday during her testimony. And I think that there's no other conclusion when you hear what happened to her and you hear what she read to you, that she was exploited. This was a matter of her being taken advantage of by the defendant. Charged him with corrupting another with drugs. And if you see there, we have 4 different time periods within which these offenses were alleged to have occurred.
Welcome to Court and Case, where the law meets the facts. Get ready to dive deep.
Alleged to have occurred. One occurred kind of, as she told you, kind of just before, around her birthday when she was turning 14 to 15, in that time period. If you remember her testimony about the first count, when she was 13, this is the one in 2021, September 2021. She's told you that she remembered that because, number one, it was the first time she'd ever smoked methamphetamine with the defendant. She was 13 years old. She remembers that specifically. She remembers that it was hot outside, that in her memory it was summertime. She remembers that it was the first time she ever smoked methamphetamine out of a bong. And she talked to you about the attachment on the bong and everything about that. She also told you the effect it had on her. She was awake for 4 days. She had I guess more of a high, you would say, than she'd ever had in her lifetime. So she specifically remembers those things. And she also told you that one of the reasons why she remembers this specific time period, that was sometime between August and September, is because she remembered that the defendant was in jail and had been released from jail in early August of 2021. And that's when she began to have contact with him, as she described. There are 16 photographs that were introduced as evidence in this case. You're going to have a chance to look at those photos. And each photo has not just a photo of, but has the metadata, the location, the geolocation information attached to each photo. And it tells you where that photo generally was taken. And it tells you the date those photos were taken. So she told you, she saw those photographs, of course it's her. She said that's in the defendant's bedroom. And she told you that she was high at the time in those pictures. And I think when you look at those, you're not going to have any doubt in your mind that she was inebriated when she took those photographs, or when those photographs were taken, I should say. There is a log of calls, and there are consistent calls throughout all the months between May and December between the defendant and the victim. The defendant, a 47-year-old man, the victim, a 15-year-old girl, and you can see how many phone calls there were between them using Facebook. She has a specific incident that kind of makes that more memorable, which is the defendant masturbated in front of her. So on that occasion, they went to his house, they smoked methamphetamine, and then he began to masturbate. And she told you that it was taking a long time. She showed a picture of herself in a bra and panties, and he was able to finish doing that. So certainly, she's 15 years old with this 47-year-old cousin masturbating in front of her. That is a memorable experience for her. The design that the defendant drew on her upper thigh when she was 13. There's a photograph from her phone that was downloaded that shows that design. In addition, when you look at the photographs that were taken in his bedroom in May of 23, you can see the design on her leg. So again, she's not just making up the idea that he did this. There's evidence to establish to support the testimony she gave you. And at the time that these things happened, she testified that he would have known what her age was. But all we have to prove is that he was reckless in that fact. In other words, that he essentially should have known what her age was. And in those circumstances, ladies and gentlemen, I would submit to you that we've proven beyond reasonable doubt that he was aware that she was a minor, that she was under 18 years of age, based on his experience with her and his knowledge of her. He's also charged with public indecency. The defendant, Eric Isaacs, who has been identified by the victim as the one that was involved in this, knowingly, we've already talked about what knowingly means, but in this case, the idea would be that he is aware of the probability that he was masturbating and that she was present and that she was a minor. With purpose of personal sexual arousal or gratification, or to lure the minor into sexual activity. Now, the second part, we're not arguing. I don't think there's any evidence he was trying to lure her into sexual activity, but I don't think there's any question that what he was doing was for his own sexual gratification. That the state has proven beyond a reasonable doubt each and every element of these offenses, and we actually find the defendant guilty.
Good morning, ladies and gentlemen. Thank you for being back here today. I also watched as you listened yesterday. I can tell that you guys are a smart group of people and you're really taking in this case. And on behalf of Mr. Isaacs, we really appreciate your time.
Sorry.
If you were anything like me, you left yesterday confused. So many question marks. Was she telling the truth? Does she remember the truth? Could somebody who has smoked that much meth remember correctly? Did something happen? What happened? Mr. Goodyear told you that it is legally sufficient to have a period of time and not necessarily pinpoint, but why? Wouldn't that have helped us all if we knew a date or a time or something that pinpointed us to all of these alleged offenses? How does my client defend against a 6-month period of time? Ladies and gentlemen, I don't have a chance to show you an alibi because we don't know a date. If there was a specific date or a specific time, perhaps Mr. Isaacs could have gone through his phone. Maybe he was out of state that day, or maybe he was at work. We don't know because we don't have that date to defend against. She said she had lots of pictures on her phone, just like any other teenager. I have lots of pictures on my phone too, and I could pretty well tell you what I've been doing every day over the past 10 years because of photos or text messages, things like that on my phone. Don't check your common sense at the door. Let's think about that. Why can't we prove this based on something on her phone? Why can't the prosecution point you to a certain day and say, look, there were all these calls between them on just this day, and this makes sense that he was on his way to pick her up, or she called and said, hey, are you on your way? And he called back and said, yes, I'm on my way. Obviously, we don't know what was said, but wouldn't that have helped? There was just something to point us in that direction. The state's job is to paint this picture for you, to make this clear for you. And if you're anything like me, I left yesterday confused, with question marks. Did this happen? How did it happen? Is she making this up? Is she credible? Testified yesterday that she had smoked meth with her brother. You had also heard her testify that her brother and her grandparents may not like it if she went over to his house, to Mr. Isaacs' house, because there was some family drama going on. She alluded to something going on. We really didn't dig into it, but we could tell that something's there. Some sort of drama is there. Is it possible that she has something against Mr. Isaacs, or maybe her brother has something against Mr. Isaacs? I don't know. I'm not suggesting that. But is it possible? You heard her testify that when she allegedly smoked with Mr. Isaacs, it was this different high, something she'd never felt before. Is it possible that maybe there was marijuana oil in there? I know I keep harping on that. I just don't know. Does that make sense that it could have been in a bong? Does that make sense that it could have made her feel weird, made her feel different? I don't know. Ladies and gentlemen, I know I'm pressing on this idea of was it meth so much, but it is so important in this case. You did not hear from a scientist. You did not hear from a toxicologist. You didn't hear from a medical provider of any kind. You did hear from the detective, but he said that there was nothing to test. So we are relying on the testimony of a child to prove that a substance was methamphetamine. She's just a kid. I don't know, but the prosecution has to prove methamphetamines. That's the drug that they have to prove for this charge to stick. There were a lot of, I don't know, I don't remember, I can't recall, maybe, possibly in her testimony. I wish I had a transcript of how many times she said that just because she didn't know. Ladies and gentlemen, she knew she was coming here for a jury trial yesterday. This date has been on everyone's calendar for a long time. And I urge you to remember that. Use your common sense. Proof beyond a reasonable doubt, ladies and gentlemen, is the standard here. And the state has not met its burden of proving this case beyond a reasonable doubt. On behalf of Mr. Isaacs, I ask that you return the only verdict that is consistent with the evidence, the law, and your oath, which is not guilty. Thank you.
You're not going to hear the judge instruct you that I'm required to prove a specific date beyond a reasonable doubt, because it's not true. People are convicted in the state of Ohio every day of the week when they're charged with date ranges. Certainly, there are going to be things that she does not remember, and Ms. Kirby asked her a number of different questions. But when it came to the really important specific issues you're going to decide, she was very specific and she was very certain. For example, how many times did you hear the defense attorney ask her, "Are you sure it was meth?" Over and over and over again. And this 18-year-old kid sat there with this adult asking her over and over and over again, "Are you sure?" "Yes, I'm certain." "How are you sure?" "Because I've used it for a long time." "Are you sure?" "Couldn't have been this." "No, I've never smoked marijuana oil." "Are you sure?" "Yes, I'm sure." She described to you why she's sure, all the different characteristics of methamphetamine, and it's exactly the same thing that he gave to her. I've talked about their ages. When you look at that call log, you can count if you'd like to. I have. 2023, May 21st, 2023 till December 29, 2023. There are 138 Facebook calls between a 47-year-old man and a 15-year-old girl. Why is that? 105 of those calls were initiated by the defendant. She told you about how he would try and get her to come over, Why is a 47-year-old man on Facebook calling a 15-year-old girl 105 times? And why would you need to talk to your 15-year-old third cousin 138 times in a 6-month period of time? The same thing with the timeline from 2023. 164 contacts, and that includes messages, phone calls, everything. 164 contacts between a 15-year-old girl and her 47-year-old third cousin. 125 of those contacts, 125 were initiated by him. Now, why is that? It's because what she's telling you is what happened. In a normal relationship, a normal cousin relationship, which the defense would want you to believe was the situation, you don't have that kind of interaction between them. There was a falling out between Eric and her brother. And she said, maybe something was there. Well, guess what? Miss Kirby had the ability to question. She could have asked, what was the problem? Did you not like Eric? What came of that? Why is that? Did she ask any of those questions? No. She wasted a closing argument to allude that, well, maybe there was a problem with no information whatsoever to support it. What's her motive to lie? This case began with a trauma letter. She had no expectation the police were ever even going to get involved. And again, talking about credibility of a witness, she told you that part of the reason she was conflicted about the idea of reporting at all is because she bears the responsibility of her own choices. I mean, she's 18 years old. And she's telling you that the reason why she was reluctant is because, hey, I made the decisions. I'm the one that decided to go over there and do this. But what does she do when she testified? I asked her, did he ever touch you sexually? No. Did he ever do this? No. She had every opportunity to say whatever she wanted. And when she had a chance to make it worse for him, she didn't. And by the way, if you say, I don't remember, I don't know to things, that's called being truthful. He is on a FaceTime call. At this point, he is 47 years old. 47 years old, talking to a 16-year-old girl. And in that FaceTime, what is he doing? He is smoking methamphetamine from a bong. Now, she screenshot that and sent it to him with that cartoon character, basically to make fun of him, like, you're an idiot. But why? Why would he feel comfortable enough to smoke methamphetamine in that phone call with her? The answer is because he had done it before. He had done it before, just like she said. And ladies and gentlemen, when you consider all this evidence, when you consider all the exhibits and the testimony, I would submit to you that the state's proven this case beyond a reasonable doubt and ask you to find the defendant guilty as charged. Thank you.
Without disclosing the nature of the verdict, has the jury reached a verdict?
It has, and it's been unanimous.
All right, if you could give the verdict forms to Ms. Karoko. Verdict form reads as follows. Count 1. We, the jury, find the defendant, Eric Isaacs, guilty of corrupting another with drugs. We further find the substance was methamphetamine, a Schedule II substance. There appear to be 12 signatures attached. Verdict form. Count 2. We, the jury, find the defendant, Eric Isaacs, guilty of corrupting another with drugs and find the substance was methamphetamines. Count 3 is also a guilty finding. Count 4 is a guilty finding, 12 signatures again attached. Count 5 is a guilty finding, signatures attached. Count 6 is a guilty finding, also with finding the substance was methamphetamine, a Schedule II substance. You may be seated. We're on the record outside the presence of the jury. Mr. Goodyear, anything from the state?
Your Honor, I know Mr. Isaacs in custody, but obviously we ask you to revoke his bond and hold him pending sentencing, and we would ask for a separate sentencing date so the victim be present to address the
Okay.
court.
I mean, he doesn't have a bond right now, so.
Okay, I didn't recall whether he had, but other than that, we just asked for a separate sentencing date so the victim can be present.
Ms. Kirby?
Nothing, Your Honor.
All right, we'll come back in 2 weeks.
Why not just sentence me since you just lied? You guys know that I did not do this. I know you do. I know you know me, man. I've dealt with you for a lot of years, and I tell you the truth.
Eric, enough.
All right, I'm sorry.
Mr. Isaacs, you know, if you want me to sentence you right now,
Please.
I can,
Please
but
do.
I don't want to.
Please do.
Actually, I can't because the victim's not here.
Right.
I can't even if I want to.
Why my life's going because of a lie? It's a lie, man.
All right, we'll set this for sentencing in a couple of weeks.
Thank you, Judge.
Thank you, Judge.
All right. If you can't, go see Miss Idle now. Let's get you in as soon as we can. All right, we're in recess.
The verdict is finally here, and the tension is overwhelming. Jurors spend days listening to testimony, reviewing photographs, phone records, and evidence surrounding allegations that a middle-aged man supplied methamphetamine to a teenage girl and repeatedly contacted her over several months. The defense argues the timeline is too vague and insists the prosecution failed to eliminate reasonable doubt. Then, the jury files back into the courtroom. One by one, the verdicts are read. Guilty. Again. Guilty. Every major charge ends with the same decision. The defendant immediately protests, insisting everyone in the courtroom knows he is innocent. Before the emotional exchange can continue, the judge firmly cuts him off, reminding him that sentencing, not argument, is next. In only a few unforgettable moments, the trial reaches its dramatic conclusion as every guilty verdict reshapes the defendant's future.